Thank you very much, Pam. Well, hello, good afternoon, and welcome everybody. My name, as Pam has said, is Philip Moser. For the next 90 minutes or so, I will be chairing this panel on class certification in collective action. Joining me, we have a class act of expert commentators, all of whom are steeped in this subject, and they are Boris Bronfentrinker, who's a partner and co-head of the competition litigation practice at Quinn Emanuel, Kenny Henderson, who's partner at CMS Cameron McKenna, and a particular pleasure to have with us Dr. Lawrence Wu, the president of NERA. The structure of this afternoon is that each of the panel will hold forth on a topic of their choice for approximately 10 minutes or so, at the end of which I will invite our two discussants into the conversation, who are Dr. Ai Deng of NERA, an associate director, and Stefan Kuppen, who is a barrister at Monkton Chambers. Ai and Stefan will then give us their take on what the panelists have had to say, following which there will hopefully be a lively panel discussion answering questions from you, our equally expert audience. Now, the principal focus of this panel discussion will be developments in the UK in relation to collective actions, although we'll hear mention of what happens in other jurisdictions. Collective actions can, of course, take a number of forms. In this jurisdiction, they can happen in the High Court, in the Chancery Division or the Commercial Court, whether in the form of a group litigation order or a joint claim by many claimants. And perhaps the classic example was the air cargo cartel litigation, which was an attempt at starting it out as a GLO, a group litigation order, and ended up as a mass claim of 600 odd claimants, all managed together. But our particular focus today is going to be collective actions in the Competition Appeal Tribunal. And as almost everyone who's listening to this is going to know, since the 1st of October 2015, it has been possible to apply for certification of a collective action in the CAT by way of a collective procedure order, or CPO. The criteria are whether the CAT is satisfied that the claims are brought on behalf of an identifiable class, they raise common issues, and they're suitable to be heard in this way. And in so doing, the panel of three at the CAT will consider whether these are appropriate means for the fair and efficient resolution of the common issues, whether the costs and benefits of collective proceedings justify it, whether there are any similar proceedings brought by any class members, whether the size and nature of the class, and in particular, whether it's possible to determine for any one person whether they're a member of the class is going to be appropriate, and also whether the claims are suitable for an aggregate award of damages. A CPO may be on an opt-in or opt-out basis, and we're going to discuss today what is happening, and more importantly, what will happen in the future in relation to these CPOs. Those who had the privilege of listening to the president of the CAT, Sir Peter Roth, in his keynote address to this conference on Tuesday, will have heard him explain how so far there have been two decided CAT CPO cases, Pride Mobility Scooters and Merricks, neither of which were certified. Both enjoy somewhat extraordinary facts, with Merricks in particular having a potential class size of 4 million people. Merricks went to the Supreme Court on the question of the standard of proof required at the certification stage, and its own judgment is expected tomorrow, so just too late for us. But Boris will shortly be telling us all about what might happen, being careful not to break the embargo around the judgment, not yet in the public domain. Now, stayed behind Merricks are a number of what the president has called more traditional collective claims, brought on behalf of consumers of various goods and services. The largest is the trucks claim, following the collision on the trucks cartel, There is then the Gutman case, the Boundary Fares case, which is a claim brought on behalf of London rail travellers. And it's interesting to note that is a standalone abuse of dominance claim brought under UK law only, not EU law. So maybe an interesting pointer as to what happens post-Brexit. And there are others, notably O'Higgins and another, which are the FX claims. Follow-on claims arising out of the European Commission cartel decision on spot foreign exchange markets. And that's interesting, at least because it features a carriage dispute for the first time in the UK. So all of these pent-up claims are waiting to be unleashed upon an expectant world. And the starting shot will be fired tomorrow in Merrick's. And here, in a starting position, is Boris Bronfentrigger, who will kick us off and tell us all about it. So Boris, if I may, over to you.
Thank you, Philip. Whether the starting gun will go off tomorrow or whether the gates get shut tomorrow, we'll have to wait and see what the Supreme Court decides. But either is possible or something in the middle, I guess. As you said, I will try and navigate my presentation subject to the terms of the strict embargo. Had the judgment come down last Friday, as initially was proposed, this would have been a very timely conference. As matters stand, we'll be talking about things today, and no doubt then everyone will be talking about them again tomorrow once we see what the Supreme Court does in fact rule on the Merrick's MasterCard case. But what I was planning to do was I guess sort of talk about how we've got to the Supreme Court and sort of the issues that stand before the Supreme Court for its determination tomorrow, and therefore, you know, how that may impact collective actions going forward in this jurisdiction. And I may leave it to others to speculate where the Supreme Court may come out and what that may mean afterwards. But, you know, as you said, you know, the case of Mr. Merrick's is in one sense unique, but in another is one that we and I always believed was one for which this regime was built, you know, in one sense. And if the regime can accommodate a claim of the one being brought by Mr. Merrick's, arguably it should be able to accommodate all other types of consumer collective actions. And if not, then there are questions as to whether or not this regime will or won't work. And many people have got many differing views on that and whether or not the Merrick's claim was the right litmus test. But as I say, the Supreme Court has before it probably and potentially maybe the largest collective action brought. Our US colleagues here from NERA may have information, but as we understand it, it probably is the largest collective action ever brought. And, you know, in a sense, it allows the regime to be fully tested as to its limits and boundaries and how it's to operate. The claim that we brought was on behalf of all UK consumers, which we estimate the class size to be 46 million people. And as many people know, the damages sought is very significant. It was originally estimated at 14 billion when the claim was filed. Obviously, interest has continued to run on that claim whilst we've spent the last 4 years navigating from the CAT to the Court of Appeal and up to the Supreme Court. And obviously some questions were raised at the CAT stage and since as to whether or not, you know, that claim size will need to be reduced depending on issues around pass on and the quantification of pass on. But on any view, it's a very sizable claim in aggregate, but one which, if brought on an individualized basis, is not really feasible for individual consumers to bring their own claims. And I think that's something that's been accepted both by the CAT at first instance and obviously was an issue before the Court of Appeal and something that was argued quite strongly in relation to before the Supreme Court as well. The claim is obviously on its breadth also very large. It covers all purchases that were made in all merchants in the UK that accepted MasterCard cards over a 16-year period, and is brought on as a follow-on claim, relying on the European Commission's decision. And whilst that decision relates to cross-border interchange fees, that the claim being pursued is in relation to cross-border and domestic, and the arguments are that the cross-border fee effectively sets a benchmark or sets a floor below which the domestic interchange fees wouldn't go, and that's the sort of causal link from the finding on cross-border interchange fees into domestic fees. Now, when we first brought the claim, that obviously was heard by the tribunal. At the time the claim was filed, we hadn't as yet even had a ruling from the tribunal. The scooters case was at that stage hadn't been decided, and that was the only other claim that was brought. And as you say, in a sense, that was right at the other end of the extreme, where it was a relatively small class seeking relatively small damages based on a decision of the CMA or the OFT, and so you had these two polar extremes. Now, the CAT refused certification at first instance, and there were two challenges before the CAT principally. The first one from MasterCard was as to Mr. Merricks and his being authorised to be a class representative, and the second was as to the eligibility of the action to be brought as a collective proceeding. The tribunal was with us in relation to Mr. Merricks. Mr. Merricks was the former chief financial ombudsman, a lawyer, an experienced consumer advocate, and the tribunal was very satisfied that he had the necessary skills and abilities and commitment to pursue the claim on behalf of the proposed class. And also there seemed to be no issues with the funding arrangements that were in place at that time. Where the tribunal wasn't with us was in relation to the question of suitability or eligibility of the claim. And in that respect, there was a great deal of reliance was placed at the time on Canadian law, and the position under Canadian law. It was, I think, agreed by everyone that, and the tribunal, that the appropriate test for certification was that set out in the Canadian Supreme Court decision of Procise, and everyone proceeded on the basis that the Canadian regime was the one closest to the UK regime, not the US one, and that one could draw from the Canadian regime to assist in the analysis of these very early first cases on collective actions. Now, in relation to the question of common issues, the CAT was with us in many respects, that there were many common issues, but it was against us on the question of whether or not the issue of pass on from the merchants to the consumers was a common issue. The CAT determined that that was not a common issue. Now, significantly, the CAT said that that wasn't terminal to the collective action being allowed to proceed, on the basis that in the UK, unlike in the US, there is no required for predominance. So it is possible for a collective action to address issues which are not necessarily common, and that wouldn't preclude a collective action going forward. But the finding in relation to pass on not being a common issue did become very significant as to the remainder of the CAT's judgment and its reasons for ultimately refusing certification. Now, another key finding in the CAT was in relation to the concept of aggregate damages. Now, this was a new concept introduced by the legislation for the purposes of this specific regime. And there was no question that aggregate damages was obviously now available. But what was hotly contested, both at the tribunal and then in the Court of Appeal, was what is the significance of aggregate damages, and how does one align the concept of aggregate damages with the well-established common law principles on the compensatory principle of damages, and that damages had to be compensatory for the loss actually suffered. So that was one issue that the CAT determined in this case that it wasn't suitable for the award of aggregate damages because of the findings it then made about the inability to achieve a compensatory outcome to the class members, and I'll come back to that. It also determined that whilst the experts Mr. Merricks had instructed had come up with a plausible methodology for the determination of pass on, the tribunal wasn't satisfied at this stage that there would be sufficient evidence available to those experts in order to implement that methodology. And so on that basis, the tribunal ruled that it was simply not suitable because it wouldn't produce an outcome at the end that would give rise to the ability to award the damages being sought. Now, on the specific question of aggregate damages, the tribunal also went on to consider the issue of distribution. Now, this was a little bit surprising in the sense that distribution isn't identified in the legislation and the CAT rules as a relevant consideration to the question of certification. And but what the tribunal determined was, in reliance on the common law principles about compensatory damages and the fact that in English law, damages had to be compensatory to the loss suffered, the tribunal determined that it was necessary to look at the question of distribution, or the proposed distribution, to see whether or not, in the end, the aggregate award of damages would, even applying a broad axe, give rise to a compensatory outcome to the class members. And the tribunal ruled that that was not going to happen in this case. And indeed, Mr. Merricks didn't suggest, and we hadn't suggested that it necessarily would happen. Our arguments were that it didn't have to be compensatory, but rather that the distribution had to be fair, and that fair was different to being compensatory. And so our argument had been that so long as it is compensatory to the class as a whole, that was sufficient, and that therefore distribution had no relevant consideration to be played at the certification stage. The tribunal disagreed with us, and that was yet a further reason why it said that it would not certify. So, having been unsuccessful on those grounds, Mr. Merricks then sought permission to appeal. Now, that of itself was a nice little issue, because there was a question as to whether or not there was a right of appeal or a judicial review as to the question of a refusal of certification. And that issue itself had to go to the Court of Appeal, and there was a judgment from the Court of Appeal. Initially, the tribunal had ruled that there was no right of appeal, that all that was entitled to was a judicial review. Its guidance had said that as much, and therefore it refused permission to appeal on the basis there was no right of appeal. Now, that said, that went to the Court of Appeal. That was taken as a preliminary point, and the Court of Appeal ruled in favour of my client, Mr. Merricks, and it ruled that there is a right of appeal from a refusal to grant a CPO application, and that it wasn't limited to a judicial review. And then obviously the court moved on to hear a rolled up determination of the question of permission and the question of the appeal itself. And Mr. Merricks was successful in a unanimous decision from the Court of Appeal, the leading judgment being given by Lord Justice Patten. And he identified, or the court identified, essentially that there were 5 errors of law that had been made by the tribunal. That the first one, and significantly, was as to the common issues, where it was ruled by the Court of Appeal that the issue of pass on from the merchants to consumers was a common issue. And significantly, what the Court of Appeal determined was the question, first of all, the test requires whether the issues are same, similar, or related. And that's wider than having to be exactly the same, obviously. And to that end, what the Court of Appeal determined is that it doesn't need to have a common answer. The question is there a common question that needs to be resolved, and can it be done by way of a common methodology? And in this case, as the tribunal accepted, that there was a plausible methodology from the experts of Mr. Merricks, and that therefore, even though the outcome may be different for the various different sectors of the economy as to how much pass on occurred from merchants to consumers, it was nonetheless a common issue, because the question and the methodology were common. The outcome could be different. So that was the first error, and a significant error, because the Court of Appeal accepted that then went on to infect a number of the further rulings that the CAT had made. The second one was as to the availability of the data. And we'll obviously hear from Lawrence soon about how the experts see this. But essentially, the Court of Appeal ruled that the CAT had set the standard too high. Okay, and that all that was required was essentially that there be some evidence available, and that evidence could be used to implement the methodology. It didn't need to be satisfied at the certification stage that the methodology could be applied to determine all of the issues and all of the questions in relation to all of the damages sought. That was too high a standard that was put by the tribunal. What was said is that there isn't a requirement to go out and gather the data. There isn't a requirement to implement the data at this stage. All that's required is to be able to show that there was sufficient data out there. And relevantly to that fact, the position that MasterCard itself was taking in relation to merchant actions, where it was arguing that the merchants didn't suffer the loss because they had passed it on to consumers, was itself relevant as a consideration as to the availability of evidence, because presumably MasterCard had made these presented this defence under a statement of truth, and therefore there was a basis for that defence. So here too, that the Court of Appeal said that the tribunal had set the standard too high, that the standard was no more than that of a strikeout, and that all that was required was that there is a good arguable case on the papers, and that there is evidence from the experts to say that they will be able to implement the methodology that they're proposing with evidence out there, even though it may not be possible in relation to all of the issues for all of the loss being claimed. The CAT also related to that, the Court of Appeal related to that also stated or concluded that the CAT had conducted a mini trial, impermissibly so, and that the certification, whilst the CAT obviously had an important gateway function, and that the legislation recognised that there was a need to ensure that cases only go forward which are properly justified, that the CAT had again taken its position as too high a standard, and that in essence that it had conducted an improper mini trial, including cross-examination of experts. So it was said there that was yet a further error that the CAT had committed. And finally, and significantly, on aggregate damages, the Court of Appeal ruled that this was a new form of damages, and it was going to be a need for the common law to adapt to the fact that the government had determined that in the context of a collective action, the damages could be awarded to the class at large. And as a result, there was no obligation for the damages to then be compensatory to any individual member of the class. The question was one, as I said, of what is fair, and in many cases, the fair distribution would be one that is compensatory or reflects the compensatory principles, but it need not, and it would depend on the facts of the case. And in this case, where you're talking about a large period for a large class over a long period of time, that it may prove to be not pragmatic for there to be a methodology that would be would give damages down to a compensatory level to the individual class members. And it's very much a case of not letting the perfect be the enemy of the good. And the Court of Appeal recognised that. And to that end, the Court of Appeal ruled that distribution wasn't a relevant consideration at the certification stage, and that was yet a further error the tribunal had committed. So it allowed the appeal, and it remitted the case back to the tribunal for determination in accordance with its reasoning. And so we had a situation where we have two fairly polar extremes in terms of the CAT's interpretation of the legislation and the Court of Appeal's interpretation. And what is fair to say, and this was an issue that was heavily also argued in the Supreme Court, is the question of the extent to which one has to consider the policy behind the regime, and what was Parliament's intention in introducing this regime. We've always argued, and the Court of Appeal accepted, that it's clear that the legislative intent was to facilitate these actions, that these are claims that couldn't be brought before, particularly for consumers. The key focus here is obviously for consumers. Corporates have hitherto been able to make use of the existing regimes that are available to them and to bring their own claims, or as Philip explained in the context of air cargo, to group themselves together. But that's not something that's really been able to work for consumers. Grouping consumers, GLOs, they've all been very, very difficult to do these sorts of things. And so that was what Parliament had intended. And yet the tribunal took a view that these individualised claims and these indirect purchaser claims had always been difficult, and nothing has changed. And the tribunal expressly made that comment, a comment which the Court of Appeal took issue with, and saying, well, that fails to have proper regard to what Parliament had intended. And that was a key battleground in front of the Supreme Court as to the question of how does one interpret the words on the page, and what weight does one give to the stated intention and objectives, particularly in the context of a claim like Mr. Merrick's on behalf of consumers. The other key issue, obviously, which we had argued quite strongly for, and which again found favour with the Court of Appeal and was again argued before the Supreme Court, is the fact that what is going on here is an aggregation of individual claims. And one has to have regard to the question of, well, are these issues that an individual claimant would face, and what's distinct if they're then brought in a collective action? And many of the issues around pass-on are there whether or not one is suing as an individual consumer, or whether one is suing as part of a class obviously an individual consumer who would have made purchases from many, many different merchants over a long period of time would similarly have the difficulties of showing the extent to which each of those merchants had passed on the interchange fee to the consumer, including also where they're making purchases, for products where they may not have even used their card, because the prices, as we say, would have been passed on to all products. And in that situation, if the claims were permissible to be brought in the context for an individual, there's no reason why the aggregation wouldn't be more suitable, and that's the appropriate mechanism, and that's why it is a suitable claim. So as I said, obviously these were the battle lines, and we don't have to wait long now to see what the Supreme Court's going to say on them tomorrow morning.
Thank you very much, Boris. It was fascinating. The essential question as to whether the standard to be satisfied at the certification stage is equivalent perhaps to that of summary judgment, or something rather higher, which we will all know tomorrow. So thank you for that report from the trenches. And I'm going to ask Kenny now to tell us some more about collective procedure actions here and also abroad, please.
Thanks, Philip. I was going to speak, I've been asked to speak, give a little bit of an oversight from the European view, kind of an update on what's happening elsewhere, but then I'm going to come back and talk about some of the thematic issues that can arise from a kind of an exacting approach at certification or a lower bar, and some of the kind of contrasting themes there, the intersecting themes. So in relation to what is happening elsewhere, I'm going to briefly cover 2 European countries and then speak about the European Directive on Representative Actions. The 2 countries I'm going to first speak briefly about: Portugal. Portugal has had an opt-out class action procedure available since 1995, but it's not something that's always made the news over in the UK in the area that we're all active in antitrust litigation. That was until last week, where a claim was filed, an opt-out claim was filed against MasterCard, and it has only been in the last couple of years, since June 2018, that the Portuguese mechanism has been available for competition litigation, and this is actually the first antitrust litigation opt-out class action that's been filed in Portugal. It's seeking a sum of 400 million euros, so significantly smaller than the stated sum in Merrick's, but not a small sum by any means. It's in part follow-on and part standalone, and the period which it covers is from 2000 to 2019, so a full 19 years. And so that, in that respect, at least, it is broader than the claim in Merrick's, which of course covers a period of 16 years. The Portuguese procedure is largely on paper, but the court has got the ability to reject a claim, but there's no stated certification stage. So it'll be very interesting to see how the Portuguese courts approach claims, sprawling claims of that nature. Next country I want to comment on briefly is the Netherlands, which is a kind of a country that we're used to hearing more about in the context of collective redress. It's got a long and innovative history in that area. One of the interesting features about Netherlands is their kind of mass settlement law, which has got extraterritorial effect. It can work on an opt-out basis even beyond the borders of the Netherlands, although there is some academic dispute as to how far that can work. But the Dutch courts have accepted it having a degree of extraterritorial effect in the Shell and the Converium cases. It's not been used a great deal, that mechanism. It's only been used 9 times, and that's perhaps because there hasn't been a corollary class action mechanism to act as a hammer to encourage settlements. But that changed in January of this year, when the Netherlands did introduce an opt-out class action mechanism, which is available for all causes of action. It's got a slight retrospective effect, covering events dating back to November 2016. It does have a certification stage, where the Dutch court will consider a number of factors, including whether the matters in the claims and the questions of fact and law are sufficiently similar. The territorial scope of that device is restricted to persons domiciled in the Netherlands, but like the UK collective redress, the class action mechanism, persons domiciled out of that jurisdiction can join, but only on an opt-in basis. So then, taking a step up and looking at things at the EU level, I'm going to turn now briefly to the Representative Action Directive, which was formally published in the official journal just last week. There's a lot going on in these couple of weeks. It's going to come into force at the end of this year, and member states will have up to 2 years to amend their domestic law as required by the directive, and a further 6 months to bring any amendments into force. So what does the directive do in broad terms? Well, it sets out a series of minimal procedural standards for the availability of collective redress measures in each member state. And significantly, the requirements only apply to claims by consumers, so there's no corporates being drawn in. And the measures only apply in relation to claims brought for a breach of the European instruments that are appended to the directive. So it's not for all causes of action. They cover a broad range of sectors and types of claims, including product liability, unfair terms in consumer contracts, and data protection. So the GDPR is in there. Now, it doesn't annex any competition ordinance, and so in a strict view, it shouldn't be particularly relevant to antitrust claims, but that ignores some of the practical implications that are going to flow from the actual implementation of the directive. Because as I mentioned, the directive sets out minimum standards for making collective redress measures available, and it's open to each member state to go super equivalent and go beyond the minimum standards and to make those procedures available for all categories of claim, including antitrust cases. And virtually all member states, even those member states whose domestic law goes beyond the scope of the directive in some areas, such as where they've got opt-out redress, even those countries have got elements of their procedural law that don't meet the minimum standards elsewhere. So in the next 2 years, we're going to see all across Europe, national governments amending their procedural law, and there will obviously be a time there for consumer associations and others who will be lobbying for changes going further, and both for broadening the scope of the procedure, but also for making them yet more claimant friendly. I'm going to touch on just a couple of the key features of the directive. There's quite a lot in it, but I'm just going to call out some of the key points. So first of all, on the key question of opt-in versus opt-out, it requires that all member states have an opt-in device as a minimum. Now, when this directive was coming together, there was 3 drafts, of course, produced, one by the European Parliament, one by the Commission, and one by the Council of Europe. And although it didn't get a great deal of press attention at the time, the Commission draft actually required that each member state have an opt-out mechanism available, including for where class members are identifiable and suffered the same comparable harm caused by the same practice. And that provision didn't survive to the final draft, but it was interesting that the Commission felt it necessary, felt comfortable putting in a mandatory opt-out mechanism to apply all across Europe. Second feature I want to reference briefly is on certification. Now, the directive does say that national courts should assess admissibility requirements in accordance with their domestic law, so no change there. But then it goes on to say that any verification, any certification process should take place at the earliest possible stage of the proceedings. And no doubt we'll come on to discuss how features of certification battles impact the shape of expert evidence, but that mandatory timing issue, that requirement at European law that certification take place at the earliest possible stage, goes with it a limited access to evidence, more of a theoretical approach to the expert evidence, and so that's a potentially significant point. And the final point I just want to call out from the directive before some good news for the defendants is in relation to litigation funding. This is the first pan-European instrument that's actually had provisions in it for litigation funding. The provisions are not particularly onerous. The qualified entities, those are the representatives under these mechanisms, must file with the court the source of their funding, and also there's provisions requiring that the funder must not unduly influence the decisions of the representative. But it's, you know, it's telling here that we've got perhaps the beginning of regulation of litigation funding. And then finally, as I mentioned, it's not all bad news for defendants. Buried away in paragraph 9 of Article 3 is a requirement that consumers reliant outside the country where a claim is filed must proactively opt in if they wish to participate in a claim. So what that means, of course, is that for countries that have opt-out mechanisms or will choose to implement opt-out mechanisms, they are precluded from having the borders of that opt-out mechanism extending beyond their own territory. Now, that would be a controversial thing to be doing anyway, and potentially offending against principles of comity. But this is an overt prohibition of any such mechanism, you know, now enshrined in European law. So that's kind of a brief tour of some of the things that are happening in Europe, and I wanted to come back and talk about some of the themes of the standards of class certification, you know, contrasting some of the points Boris has been making, and also what we see in the US. And this question of the process standard, you know, that they're considering, the CAT would consider the plausibility of the expert methodology and availability of evidence necessitates towards kind of more of a theoretical analysis, theoretical expert reports, not necessarily applying the methodology to facts. And, you know, in the US, you know, there is the rigorous analysis approach. And the rigorous analysis approach isn't merely, by the meaning of the language, isn't merely, you know, a higher standard. It's also a direction as to how a court may approach. You know, they actually must analyze it, and it's difficult to imagine any analysis without applying a methodology to facts. So of course you have a much more developed approach. That then takes us into questions of applying it to what, and questions of disclosure. And of course in the UK regime, we have around the rules very limited scope for disclosure, and those rules haven't been fully tested yet, but it's quite clear from the rules that it's supposed to be very narrow. Contrast that again with the US, where there's very broad disclosure, including on the merits of the case, where that is relevant to the question of certification. And under the UK regime, merits can come up, but that is only where the CAT is deciding between whether to certify on an opt-in or on an opt-out basis. The CAT guidance also there suggests a very high-level approach to the merits, not expecting detailed submissions. And it also goes on to say that where it's a follow-on claim, that it would be virtually assumed that that's sufficient merits. And there was an obiter comment to that effect also in Gibson and Pride. And then final kind of thematic issue is kind of whether we'll be looking at an inquisitorial or adversarial approach to expert evidence at the certification stage. And we've seen so far in the UK a bit more of an inquisitorial approach, certainly more than in the US, with it more being a debate between the representatives expert and the CAT, whereas in the US, you know, contested expert reports being filed, and actually the court going further and making findings as between those expert evidences, those expert reports. So what does all this mean, and how could it impact defendant strategy? Well, in terms of how the, you know, danger of sticking my neck out here, but in terms of, you know, how the system has been designed, by limiting disclosure and having certification earlier on, it, you know, inevitably tends towards having a slightly more theoretical expert report. Doesn't necessarily mean there's going to be nil opportunity to test that, but it's going to be less than if disclosure was available. And that, you know, makes it more difficult for defendants to challenge expert reports when they're at a more theoretical level. And it's also more tempting for courts to permit claims to proceed, I would think, as a structural design, tending towards a lower threshold for certification. We may see, where further areas we'll see to develop, we may see the parameters of Rule 85 being tested, and that's the provision that allows the tribunal, if it chooses, to decertify a class if it considers that the certification criteria are no longer met. And that's got potentially two consequences, the existence of Rule 85. First, we saw in the trucks the trucks class actions and the preliminary issues ruling in October last year, that where there was a question mark over the representative's ability to pay adverse costs, and that issue going to the question of whether or not the claim should be certified, the CAT actually ruled that one of the features that militated in favour of certification, and well, at least of not declining to that basis, was the fact that the possibility of decertifying the class later on gave the CAT some comfort, and that obviously tends towards a slightly lower certification standard. The second point in this, which I think is a bit more interesting, is how would the CAT approach any attempt to reopen certification? And on the face of it, Rule 85 simply says that the same standards must be applied. It just relates back to the Rule 79 standards, suggesting the same test. But again, the ruling in the trucks case implies that the better visibility of the underlying facts later on, as a case has developed, could in fact lead to a different result. And that's something for defendants to consider in a broader sense when considering issues of the suitability test, and perhaps the representatives approach their model for an award of aggregate damages when later on more evidence is available after disclosure. So again, if we get a low certification standard, I've not seen any the judgment, of course, but if it is a low standard or a lower level of analysis applied to expert reports, is that a disaster for defendants? I'm not sure necessarily it would be. Yes, there will be settlement pressure. The ability for undistributed sums to come back to the defendant would be an attractive element at the relevant point. But by its nature, with a low certification standard, the expert methodology hasn't been tested. And in the US, it has been tested to that robust standard earlier on. So it's a very different dynamic going in towards trial. But and this will be my final point, another very important area that we will see developing is between certification and trial and arguments over case management and defendants trying to have preliminary issues addressed. And there may be more scope for that in standalone claims and dominance claims, where there's an ability to reshape the structure of the claim and potentially going back to certification at that point. So there's a lot of unanswered questions, lots of scope for lateral thinking as we move beyond certification.
Thank you very much, Kenny. I think that's an excellent cue for Lawrence on the role of the expert in all of this at various times at the certification stage and then carrying on. It's a dynamic process. So Lawrence, if you will, over to you, please.
Thank you, Philip. Well, how the tribunal and the Court of Appeal have ruled in Merrick's is really interesting. And I'll start with a few high-level observations that came to mind as I read the decisions from the perspective of an economist, of course. And perhaps the observations might be useful for you or to keep in mind as you read the Supreme Court's decision tomorrow, as we reflect on the implications going forward. And then I'll get into the role of economics in a collective action. All right, two observations. My first observation is one of hope and not despair. You could ask yourself whether we really need such deep thinking and analysis at the certification stage of the proceedings. You could ask yourself whether we really need to get all this data and delve into the econometric methodology at this stage. And you could ask whether we really need to be so careful to get everything right at this stage. Yes, it is a lot of work and a lot of brain power, but this is the nature of human progress. We want to get things right. We want to make better decisions. If you have seen the movie Moneyball, you know how data analytics transformed baseball. Could we make decisions based on gut feel? Could the courts do that? Sure, of course they can. But can we make better decisions with data? I think so. And that is what should give all of us hope. And I'm not saying that the decisions are easy to make or that the decisions will get easier to make going forward. Clearly, all of these decisions are difficult and reasonable people can come to different conclusions. But again, the complications here, or what we might see as complications, really could be viewed as progress. And here's my second observation, and it is in part a policy issue and in part a statistical issue. And it has to do with making decisions under uncertainty, especially informational uncertainty, which means dealing with something called type 1 and type 2 errors. Okay, and so what's a type 1 error? A type 1 error is a false positive. So that might be if a court were to deny a CPO, that should have proceeded as a collective action. I would think that the courts don't want to deny classes that should be certified. And then there's also the possibility of making a type 2 error, which has to do with false negatives. A type 2 error would occur, for example, if a court certifies a class that should not be certified. Okay, so courts don't want to make this type of error either. Now, if you don't want to make type 1 errors, then you're going to be more inclined to certify a class and let the collective action move forward. If you don't want to make a type 2 error, then you're going to be more conservative and you're going to be stricter in what classes get certified. And this is how policy, public policy is evaluated all the time, type 1 and type 2 errors. Now, which error is more costly? Well, that's a great question and worthy of a good policy discussion. I'd be interested in what the other panelists say about that. But that is something that I think we should think about as we think about how the CAT made its decision and how we think about the Court of Appeal made its decision. Now, if you worry about the time and cost of litigation on the defendants, yeah, then you're going to want to avoid the type 2 error, and you're going to certify and you want to avoid certifying classes that should not be certified. But if you worry about consumers being harmed and not having their day in court, then you want to avoid making type 1 errors and denying classes that should be certified. So again, different people might view the two types of errors differently. Some people worry about type 1 errors, others worry about type 2 errors. And I think the Merrick's decisions show how hard it is to make decisions under informational uncertainty. And type 1 and type 2 errors, they're not easy to evaluate, and they can often get in the way of each other because they might not be, it's hard to get both minimized at the same time. All right, so that's a segue into how I see the role of economics in collective actions, or class actions that they're called in the US. One would hope that economic analysis contributes to the process by doing two things: providing facts and analyses that will help the courts make better decisions, and providing facts and analyses that will help the courts get to the best decision and minimize these type 1 and type 2 errors. Now, if you're wondering why there is so much expert testimony these days, that's part of it. It's economists doing their job. I don't think it's because the world is more hostile to class actions or collective actions, or at least I don't see it that way. I see the fact that we need more economics, and we see more economics in the certification phase as a consequence of the world becoming more complex. Pricing is more complex today than it was many years ago. Supply chains are more complex. We have a global economy. How products get to market are more complex. Antitrust class certification is typically about price. Well, what affected price? That's more complicated too. So I see the use of economics more and more, and I think it's a consequence of smart thinking on behalf of both the claimants and defendants, and all part of the process of helping courts make better decisions. And of course, it's a consequence of good economic thinking too. And to give you perspective, here's a stylized version of how I see economics developed, or how economics developed in the U.S. on class actions. And maybe, and I say this, well, I'll start and then I'll say why I think it might matter or might be of interest to you. Well, for decades in the U.S., when plaintiffs brought a class action, most of the discussion was about the conditions for market power or just describing the economic theory of harm to competition. And that just set up the presumption of common impact and commonality. And that was enough for many, many years to get classes certified. And then the defendants would just respond by saying, wait a second, but plaintiffs, you have to do more. It's not just theory. You can't assume that there's impact just because you have theory. And then they would find examples of individual customers in the class and say, look, that party, that customer wasn't impacted. Oh, that customer wasn't impacted. And that's where they left it. And then the plaintiffs were countered by saying, no, let's look at some data. Let's look at what happened to average prices, say, after a cartel started. And it went up, say. And then the defense side would then respond and say, wait a second, that's not good enough either. I know the average price went up, but after the cartel started, but you haven't shown that there are individualized issues because look what I've done with the data. I'm going to look at all the prices that individual customers paid. No one's paying the average. It's a wide spread of prices. And then the defense side would show a chart of all the price dispersion to show the individualized pricing. And then the plaintiffs would respond and say, well, defense, that's not good enough. You can have individualized prices, but they all move together. So even though everyone's paying different prices, after the cartel started, they all went up. Okay, and then the plaintiff's expert would then show a chart that shows that a rising tide lifted all boats. Okay, and then the defense would say, wait, but that's not good enough also, because if you look at the individual experiences, some customers or some customer subgroups had no effect. Some customer subgroups had prices go up. Some customer subgroups had prices go down. So look, it's not a uniform effect. All right, so what's happened here? Well, plaintiffs and defense side, they both improved their game. Now, throughout all of this, the legal standard didn't change, but the sophistication of the analysis did. So so how do economists help here? Well, I'm just mention two things. Well, first, all of this is in the name of helping the courts articulate a theory of harm, and therefore the mechanism by which direct purchasers and indirect purchasers may have been harmed by the misconduct. Okay. Now, when determining whether there are common issues or a damages methodology that's feasible and realistic, it is important to understand the misconduct and how that misconduct affected the way competition actually took place. And that's really the first step in understanding who is likely to have been harmed and how. And it sets the stage for developing a methodology to compute damages and what variables have to be in the model. And again, that's the first step to developing or coming to a conclusion as to whether a methodology is realistic, whether it matches market conditions, and whether it's feasible to implement. And the second thing is experienced economists can help courts assess whether a proposed methodology to estimate the overcharge or pass on is something that goes beyond something that we could do as a matter of theory, and instead something that we can actually do as a practical matter. So I think for economists to do that, then we can close that informational gap and help the courts come to a decision. Now, Boris and Kenny mentioned a couple of times that the key issue in Merrick's is the standard of review for certification and how the Supreme Court decision will shape that. And of course, they mentioned process a couple of times. Now, you could read process to say that we don't need that much economic analysis to determine whether a class should be certified or not. And that could be true, but I'd say human progress and the desire to get things right and to make better decisions will only lead to more economic analysis, not less. That is what had happened in the US, and I think that's going to happen in the UK as well, whether the decision tomorrow goes in favor of the claim of Merrick's or MasterCard. Class counsel have to compete to be named class counsel, and they're going to want to present the best case possible. There's a usual competition between defendants and claimants, and each side will want to present their best case. The courts will want more information because they need to close that gap if they're going to make better decisions. So because of all that, I think we're going to see more and more economics and econometrics presented in the courts. And I think that's going to happen regardless of what the decision is tomorrow. So those are my introductory thoughts, Philip. I'll turn it back to you and then we can have a conversation about this.
Thank you very much. That's fascinating. And it is at this stage that I'm going to invite our two discussants, I and Stefan, to join us, please. And in the first instance, before we have our general panel discussion, they're going to each in turn give us their impression of what we've all just said. Stefan, would you like to start?
Yes, thank you very much, Philip. It was really fascinating to listen to the different perspectives on what, of course, is still a field pretty much in its infancy as far as UK law is concerned. And it's probably fair to say that at the moment we're all waiting for Merrick's to be handed down tomorrow and unblock this process and tell us, at least in part, as Boris put it, where we going to come out between the two almost polar extremes of the CAT and the Court of Appeal decisions in that case. But what also struck me in the discussion, and it probably came out clearest from Kenny's comments, is that whilst Merrick's is going to give us a significant piece of the puzzle and is going to allow issues to progress, there's also a myriad of other issues that lie behind it, which haven't really been touched upon yet in UK law, and which will need to be decided in the coming years, essentially. And I thought it might be useful to briefly touch on a couple of these, and one that sprung to mind, which Philip also mentioned in his introduction, is that of carriage disputes, as it's called in the US and probably also going to be called in the UK, which of course arises if there's more than one class representative applying for a CPO for the same class and essentially the same claim, or in the same claim and for essentially the same class, I guess, rather. And so far in the UK, this has only arisen once in the FX Carter proceedings. In the trucks claims, there are also two CPO applications, but they're not necessarily competing. But in the foreign exchange cartel, there's Mr. Evans and Mr. O'Higgins on the other side, looking to represent what is essentially the same class. And it's an issue, so that could become a lot more important because, as Boris put it, or I think Phillips in the introduction actually, depending on how Merrick's is decided tomorrow, that may well open the floodgates. And one implication of that may be that a lot more of the CPO applications that we will see will be competitive as between more than one potential class representative. Now, going back to FX, it's actually one of the only judgment we had on the matter of collective proceedings in the UK since this conference took place last year. The issue there was ostensibly one of timing of a carriage dispute, but necessarily that had to deal with the question of how one is to decide such a dispute. And just for context, it's not necessarily entirely straightforward in the UK regime, because under UK law, a CPO has two requirements. One of them is the authorization of the class representative, and the other one is the certification of the claims. And on one view, and the CAT said that's at least arguable, the carriage dispute is purely an issue of the authorization of the class representative, where it sits in the CAT rules and in the relevant provisions in the Competition Act, and doesn't really deal with the question of which if the cases or which of the claims is more suitable. But on another reading, of course, and that's what the CAT observed in the end, is possibly one of the most important decisions is to pick between competing class representatives, and it's difficult to get around a consideration of the merits in that context. And as a result, the CAT took the view that it wasn't suitable to be heard as a preliminary issue and would be decided most conveniently together with the CPO as such. Now, this is contrary to international practice, especially in Canada, and I think it's fair to say that the CAT's ruling wasn't in such definitive terms as that it would necessarily establish the practice going forward, but it still raises the fundamental issue of how one differentiates between two claims. And Canadian and US precedent gives us plenty of examples of possible differentiators, but a lot of them aren't immediately obviously applicable in the UK, because of course under the UK regime, all of the cases, both or all of the cases, will have exactly the same course of action, in that there must be claims that fall under Section 47A of the Competition Act. And where there are follow-on claims, they're quite conceivably almost identically pleaded. They will also, one would have thought, almost inevitably be represented by reputable counsel and supported by law firms with plenty of relevant experience. In the case of FX, it was Scott & Scott and Hausfeld. And I can't really see the Competition Appeal Tribunal wanting to engage in looking at win rates of counsel or similar things as one might see in US proceedings from time to time. And funding similarly appears to be an issue that is becoming somewhat consensus about how that should be arranged. And there hasn't to date been any serious challenge or any successful challenge to the identity of the class representative. So my question really is, what does that leave? And is it the question that is really the hour for the creative economist, or the task for the economic evidence to differentiate which of the class representative is going to go forwards? And in FX, it certainly appeared like that's the most obvious difference between the two claims, but arguably FX is somewhat unusually complex as a market and as a theory of harm. And in a more straightforward kind of product or services-based cartel, one would have thought that the standard approach for both economists is going to be one of regression and a dummy variable for a cartel period. So how does one sensibly depart from that? And perhaps linked to that, of course, depending on what the Supreme Court finds in Marex tomorrow, it's also the question, how does that sit with the approach that the Court of Appeal at least took, and that, as Lawrence explained, is also a possible interpretation of process, that really there shouldn't be too much scrutiny and certainly not too much disclosure in the UK regime at the certification stage. And to put it in Lawrence terms, maybe the answer to that is just simply human progress, that there will have to be more and more economics at that early stage. So to put it as questions, and I'd be really fascinated to get the panel's perspective of that, is this the hour of the creative economist? And if the regime does not allow for much evidence or disclosure at an early stage, is the solution to that, perhaps looking at it in the context of Kenny's reference to Rule 85 or Lawrence's Type 1 and Type 2 errors, that perhaps the losing class representative simply gets stayed for the time being and may get reactivated if things develop, so that the decision on the carriage dispute appears in a different light? And I had a different point, but I think in the interest of time, I'll hand it back to the panel now.
I think that's a great point. Thank you. I like the idea of the disappointed team coming off the bench if something happens to the first team. So what I plan to do actually is I will ask the panel to note that question: is this the hour of the creative economist? Ask why not the Creative Council anyway? And I'll go to next though, and then we'll collect both their questions, and then I'll come back to the panel. So thank you, Stefan. Can I ask you please to begin?
Absolutely, thanks, Philip. And I also want to thank the panelists for a wonderful presentation. As an economist working mostly in the US jurisdiction, it's fascinating to learn about the latest developments in the UK, and also to recognize, as Lawrence discussed earlier, that there is a lot of overlap in terms of the relevant economic questions that one can ask. And in that sense, the US experiences can be of some reference value. So I want to first quickly go back to one of the questions that was addressed earlier or discussed earlier. And that was, how much discovery or disclosure do we need at classification stage? And to what extent the disclosure requirement affects the type of evidence that we, especially as economists, can present at that stage. Now, from a practical standpoint, I think at least part of the answer to that question is also depends on the type of industries that we're looking at. I can imagine a spectrum of industries where, on one end of the spectrum, you have industries that are largely transparent, meaning information about prices, costs, or other important market conditions may actually be readily available. So for those industries, one may be able to collect a lot of relevant and important information without a whole lot of formal disclosure. Relative speaking, of course. Now, on the other end of the spectrum, you would have industries that are largely opaque. And for those industries, I think formal requirement for disclosure or discovery will be a lot more critical. And I think at the end of the day, I do think that what economists can and should do depends on the legal standards. So that's why it's really interesting to see how the court decides on the merits case. Now, I want to switch gear a little bit and share with you some thoughts on the question that I think may be interesting to the audience here. And that is, given the heightened bar for classification in the US, how have the US courts been dealing with especially economic evidence and sometimes even sophisticated econometric evidence presented by both parties? Now, as Lawrence mentioned earlier, proving common impact, and Kenny mentioned this too. So here in the US, experts are expected to present models, economic models to quantify impact and measure damages, even at early class cert stage. So with that question, I reviewed a number of recent antitrust class action cases. And I want to share with you two observations I have. First, I think the US courts have taken a very holistic approach to assess when assessing economic evidence and really any evidence in the class cert. Courts tend to put more weight on an economist's testimony and economic theory and models when the facts of the case corroborate their economic inference. Now, I've seen also cases where the court put very little weight on an economist, on an expert's economic models, precisely when the facts of the case are not sufficiently supportive. Now, to be clear, that's not surprising. In fact, I would say this holistic approach to class cert is rather reassuring to empirical economists. Now, the second observation I have is that it is clear that the US courts have embraced this higher standard of classification, the heightened bar, the rigorous analysis standard, if you will, at the classification stage. Today, if you read a judge's opinion or ruling on class cert on economic issues, it's very common to see the judge or the court weighing evidence, economic evidence, and sometimes econometric evidence presented by both parties. And you may even see a section on regression models, dummy variable models, in one of their in the rulings on classification issues. Now, as an interesting note, recent drywall antitrust litigation, which is also a class action case, the experts from both sides had a very detailed and nuanced, sometimes discussion or debate on econometric issues. What's interesting is that the court in that case actually appointed an independent expert to help the court assess the econometric debates, the econometric issues that were brought up in that case. Now, I would say that the court-appointed expert is still very rare in the US, but I think that's a very, very good example that shows you how far the US court is willing to go and to embrace this higher standard at classification stage. So those are some quick remarks, and I look forward to the discussion.
Well, that's great. Thank you very much. So now we can have a lively debate with all of our panelists and discussants. Of course, you're not excluded. I wonder who would like to have a go first. Lawrence, it seems to me that these are areas that sound like would be useful to have your views on first, if you're willing.
Sure, I'm going to answer your question. Is this the hour of the creative economist? I think I'd answer it. This is the hour of the credible and clear economist. You know, this is where I think courts really need to get useful information. And it doesn't help, I think, for many judges to say, oh, whether I certify a class or not certify a class depends on some arcane economic assumption or a mathematical assumption that they don't understand. Okay, that doesn't help people make decisions. But I think for an economist to be able to be a very good teacher and explain what we're doing and why it's relevant, I think that's really useful. And so it's really doing the work that gives courts the information that they're really looking for. And so the more you can think about that in advance, obviously you're better off. So clear and credible, that's where I'd put it, Philip.
That's great. Thank you. I couldn't agree more. Boris, would you like to have a go at either issue or any other that occurred to you?
Sure. No, thank you very much, Philip. I think I might just pick up Lawrence's points about type 1 and type 2 errors and how they sit. And, you know, one thing I probably throw into the mix is how one weighs these up when you're looking at the difference between, I think, consumer claims and corporate claims, and you know, whether or not it's the same error that is concerning in both scenarios. You know, I'd obviously advocate, given the case we're bringing for Mr. Merricks, that when it comes to consumer claims, one probably does need to err in the side of being cautious about type 1 errors, because the counterfactual is that likely that these claims won't be brought. And that comes back to what I said, which the Court of Appeal weighed very heavily for them, was the policy behind why this new regime had been introduced. I think that stands in contrast to where there are corporate classes that are seeking to be brought, because for the most part, corporates have been able to come together. I mentioned earlier, in response to Philip's comment about the air cargo cartel, that managed to aggregate a very large group of corporates, and they were able to mobilize themselves. And so I think maybe in that scenario that the type 2 error probably weighs larger. And the question is it right to put defendants to that difficulty and the cost of defending an action which maybe shouldn't be brought as a collective in circumstances where the corporates can pursue that individually? And one sees that at the moment in a couple of the claims pending at the moment. Stefan talked about FX, and there is a dispute at the moment and pending CPO applications there. But there is a direct action that's being pursued in the High Court. So my firm, we act for a group of very large investors, buy-side investors, bringing claims against the banks in relation to the FX cartel. And so there is a question there, no doubt, as to the need for a collective action where obviously investors can pursue direct actions and are pursuing them. The same goes in trucks. And again, on that one, we happen to be on the defense side of that. And you've got situations there where truck purchasers are pursuing claims, very large numbers of them all over Europe. And so there is a question is there a need for a collective action in that sort of a scenario? So what I would put out there is that I think actually the question you pose is a good one, but I'm not sure, to use the sort of word of the day for today, I'm not sure it is a common one in terms of the answer to that question, because I think that maybe the courts should be taking it differently depending on what one's looking at. And that's why, as I say, we'll all with interest see where the Supreme Court comes out tomorrow on some of these issues. But no doubt that will weigh heavily on all these applications that are pending as to how that balance is struck. And the other point I think I would just sort of raise in terms of the creative economist and the questions of disclosure that I raised as well, I think one needs to consider, having been in the trenches, as Philip said, is the issue of costs. these are expensive pieces of litigation to bring, requiring substantial investment by funders. And the higher the bar that is set and the more that is expected, the greater those costs will be. And in circumstances where, unlike in the US, where there is the risk of adverse costs, so it's not just your own costs, it's the fact of the defendants then investing significant costs to defend the CPO. One is then potentially looking at very substantial adverse costs as well. And I think that's something that we need to all be pragmatic about and take into the round and to consider this, is that the greater the standard, the more the creativity that's introduced, the higher these litigation costs rise. And at the end of the day, I do think that one needs to remember, as I said, particularly in the context of consumers, what brought this regime to bear? The need for access to justice. The view that the government had was that there wasn't sufficient enforcement of competition laws, particularly by end users. And it's notable that most of the pending CPOs at the moment are end user claims, and indirects quite often. And so issues around disclosure and things, again, I made the point about transparency and type of market. I think there's an important question there in terms of, is disclosure going to help? In indirect purchaser claims, if you haven't got the direct purchaser bringing the claim as well, often neither side necessarily has the relevant information to address the key issue for the indirects, which is the pass-on issue. And so I'm not sure that disclosure necessarily is the magic panacea. And that's why, as I said, the Court of Appeal took the view that you let the case go forward and you see it develop and you keep it under review. And there's always that means to decertify at the appropriate time. Whether or not the second 11 will be there waiting, I'm not sure if that's the case, practically speaking. But these are all points that I'd throw out there for consideration.
Yeah, that's very interesting and valid. And just to play devil's advocate, of course, there is another view, which is that if you front load the effort with the economists and the argument, have a higher standard and more evidence at the beginning, yes, you will make it more expensive. But on the other hand, there may be an earlier point at which it is realized that the case isn't going to work, in which case you save yourself the much greater expense of having gone on. As you say, there are ways of turning it off en route, as it were. So we shall see. As ever, we're waiting for Merrick's. It's a bit like waiting for Godot this session. Godot isn't going to come today. He will come tomorrow. Then perhaps we can have another get together, although without the audience, I'm afraid. Kenny, would you care, please, to take on this ball and let us know what you think?
Yes, thanks. I mean, just listening to the observations, it's striking, I think, how many of these points are matters of policy, really. And so, Boris, what you were saying, about the debate in front of the Supreme Court, because class action and availabilities of class actions is fundamentally a question of policy. So, Philip, the point about, the saving of costs up front, is a completely, it's an important point, isn't it? Because a certification standard is intended to deny claims that are not suitable for the procedure from progressing. And if that does require a bit more costs, then so be it. For certification to mean anything, there does have to be, there would have to be claims that are denied, and on access to justice. We may see, as you say, Boris, we may see divergence of approach, whether it's a corporate group or not. And in fact, we may see divergence in approach to suitability on whether it's an opt-in or an opt-out. Other questions to be considered down the line. But on the kind of the question of access to justice, I do think to an extent that some class actions where distribution rates will be low are more of a privatization of public enforcement. Because if there is, I think there was, I'm sure Lawrence and I will correct me, but I think there was a report by the Federal Trade Commission relatively recently saying that the mean distribution rate in consumer class actions was around about 9%. There's high levels of distribution in those cases. I mean, the parties will do their level best to maximize distribution, as of course they will. And I know but these are policy arguments, and so the claimant firms will say the government was aware of that, at the time that they consulted on bringing in this new law, and they went ahead with them because to an extent it's an expropriation. Well, that's the wrong word, but you see, it's taking, if the merits are strong enough, it's taking the money out of the hands of the defendant that did commit a breach, and so distribution is a secondary issue. So yeah, I'm kind of just struck by all the policy issues. And I want to make one final point on the time for creativity. I think it's time for creativity for everybody involved, funders, solicitors and the barristers as well. And yeah, definitely clarity is better than creativity as well, though. Endorse that. But those are a few observations from myself.
Thank you very much. Lawrence, I think you had another point.
Well, Boris raised something interesting, and I just wanted to ask a little bit more about it. And it has to do with your comment that a class could be decertified after it was certified. Okay, and that actually, that made me think again about the type 1 and type 2 errors, because it means that if you made because part of how you weigh your type 1 and type 2 errors is if you happen to make a mistake, can you correct it? Now, so Boris, suppose a court certified a class, and then later, as with more discovery, it turns out that maybe it should not have been certified. Are you saying that at that point, a court could decertify the class, in which case it could remedy a decision that it made earlier?
Yes.
All right.
Yes, thank you. The answer is yes. That's what the regime provides, what the rules provide for. Obviously, we're all in uncharted territories here because we haven't even got to the certified case, yet alone a decertified case. But it weighed heavily in the Court of Appeal judgment, in the fact that in response to many of MasterCard's arguments, the view was that, you know, the reason the Court of Appeal took the view that you took a more facilitative and lower standard versus that of the CAT is because of this ability, precisely what you say, to correct the error if there has been an error down the line. Now that could mean anything from a narrowing of the class, an alteration of the class, obviously within the scope of what was there originally, all the way down to just simply saying it is no longer appropriate for it to proceed as such. You know, now, as you say, that can't be rectified if you've shut the class out from day one. It obviously can be rectified if you've let the class go ahead in circumstances where you shouldn't have. And particularly in circumstances where if it's an opt-out class, there's always a possibility for those who don't believe in the class or don't like the class to opt out. And again, coming back to my sort of dichotomy between the consumer and the corporates, for the corporates where that's the case, to opt out and pursue their own claim. Now, obviously, it's possible for consumers as well, but reality is that we're unlikely to see many consumer claims individually pursued, as we've not seen. So yes, so that is the answer, Lawrence, as to how the regime is envisaged to work, and indeed how the Court of Appeal said it should work.
I see, because there is a parallel in the merger world where largely, I would say, the competition authorities are more willing to, or they're more afraid to block a transaction that could be pro-competitive, because if they make that mistake and block the transaction, that transaction probably won't happen again. But if they clear a transaction that was anti-competitive, that turns out to be anti-competitive, they have another chance to correct it, or maybe the market will correct it, or they have another chance to review a transaction retrospectively. So that's why I think that decertification lever is an important one to think about, because that will help. I think that might help the courts think about how you want it, you know, what decisions to make in the initial step.
Thank you. I'm going to turn back to our discussants at this stage. First to I and then to Stefan. We've got a few minutes remaining. I'm going to ask each of you whether you've got any further comments you want to make, and then I'll ask the panelists for a last word.
Sure. Thanks, Philip. I will just echo what Lawrence and Kenny mentioned, and that is being creative and having that clarity when you present that evidence. And I would say, even here in the US, despite the higher standard, we do not always have all the data, all the information that we need, or we would love to have. So, so you really have to think about maximize the value of the information that you have and make the best case, and really understand the merits and understand the commonality, the common impact questions required by the law. So yes, I just want to echo that point. And it's true that even in the U.S., the information is not always available.
I quite agree. I think in both our professions, clarity and simplicity must be the watchwords. I think that my favorite saying in that regard is, if you can't explain it simply, you don't understand it. Stefan.
I think what struck me most in this whole discussion is pretty much what Kenny said as well, is that a lot of these issues in a way are questions of policy. And there's a lot of policy that now out of necessity has to be made by the courts, which may or may not be ideal. But I thought Lauren's way of putting it as a type 1 and type 2 error was actually a fascinating way to kind of summarize it all up. And the answer may well be, as Boris says, that it's a question where you end up, whether you're dealing with corporates or whether you're dealing with consumers. And really all of the issues that I had considered, including pass on, which of course is the topic of the next panel coming after us here, is it raises all of those questions. And how far do you go down to an individual level, and how far is it okay to average? And the answer to all of them is essentially where you strike the balance between those two types of errors.
Thank you. And what marvelous continuity to reference the next session in about half an hour or so. We have literally a minute and a half, I think. Lawrence, would you like to make any final observations, or indeed Kenny or Boris?
Okay, 3 C's. For commonality, we want clarity and credibility. How's that?
Perfect. Thank you. Kenny?
Yeah, I think I earlier on made an error by contrasting creativity with clarity, and you can actually have both. That's probably the thing to aim for.
And Boris, a last word from you.
I guess we all watch for 9:45 tomorrow.
That's it. Well, on that cliffhanger, thank you all very much. It's been a fantastic panel, I think, and thank you to the audience who've remained strongly with us throughout. And here's to tomorrow. Let's see what it brings. Thank you very much.
Thank you, everyone. Thanks, Philip.
Thank you.
Yes, thank you to our